Hello, hello. I'm Sharon Aboud, immigration attorney in the area of Los Angeles, California, here today to talk to you about a very important and highly requested topic. We're going to talk about VAWA and specifically about VAWA for the spouses of U.S. citizens. So if you are the spouse of a U.S. citizen or lawful permanent resident, stick around. You need to hear about this topic today. Before I get started, I want to go ahead and remind everyone to please like this video and subscribe to my channel and click that notification bell to receive notifications every time I'm here with you providing new content. And please share this video so others in our community could benefit from this very life-changing and important information. Before I get started on the requirements of VAWA, I want to go ahead and explain some background about VAWA and maybe and describe what it's about to those of you who perhaps aren't really sure what VAWA even stands for. For those of you who don't know, VAWA stands for Violence Against Women's Act. And I word it out that way because it causes a lot of confusion. It's a misnomer. First of all, it has the word violence against it. And this makes people think that you have to have been physically abused to qualify for VAWA. And I'm here to tell you that's not true. You also don't need a police report filed to win a VAWA case. It's just not true. There's also the women part of VAWA that confuses a lot of my male clients. If you are a man who is suffering from any type of abuse or mistreatment by your U.S. citizen or lawful permanent resident spouse, you may also qualify for VAWA, even though that word women is in the word VAWA. So now that I got that out of the way, and perhaps expanded your definition of who VAWA could protect, let's talk about the requirements. First of all, you need to be married to the spouse of a U.S. citizen or lawful permanent resident. Now, I do want to say one little thing. Parents of U.S. citizens and children of U.S. citizens who are under the age of 21 and sometimes under the age of 25 could also qualify for VAWA. But today, for purposes of clarity, I only want to focus on VAWA for spouses. If you're a parent or a child, hang in there. I will upload another video for you shortly. So back to this first requirement. You need to be married, okay? So you need to be lawfully married. If you are in a common law marriage state, it could be possible that you may qualify, like Texas, for example. It may be possible that you could qualify for VAWA without ever having been legally married. Now, it will be harder to prove your case because you need to prove that you were married under the definition of that state, but possible. Most states are not common law marriage states, though. I'll talk about California. California, for example, is not a common law marriage state. So that means that you need to have been, you need to prove that you are legally married. So there is some kind of, so it could have been civilly or maybe through religion, but you need to prove that you were legally married to your U.S. citizen or lawful permanent resident spouse. Next, you need to prove that your spouse is a U.S. citizen or lawful permanent resident. Now, this element sometimes could be a little bit tricky, especially for those who are maybe separated from their spouse or maybe divorced. This element could be a little bit tricky. Sometimes I've had clients that they're still living with the person abusing them. However, part of the abuse is that this person conceals all important documents from them. There are ways around that, so I don't want you to think that that's your limitation, you could still have a way to fix your immigration situation, okay? There's always a way. Please don't let that stop you. I do want to add one more thing. You need to be legally married, okay? You could be living with your spouse still, okay? It doesn't matter if you guys are still together. There's a lot of people who are still living with their abusive spouse. And that wouldn't stop you from qualifying. You could also be separated. You don't need to be living with your abusive spouse. And third, you could even be divorced. That's right. You could be divorced and still qualify for VAWA. If you are divorced, though, you need to file quick. You only have 2 years from the date of your divorce to file for VAWA. Third, you need to prove that at some point you resided, that you resided with your abusive spouse. Okay, so you need to prove that at some point. It doesn't, the law doesn't specifically state how long, but obviously the more, if you only lived with your spouse for a month, it could be trickier to prove that you actually live together because there's less documentation to back it up. Again, trickier, but not impossible. And then there's the element of good moral character for 3 years. So you need to prove that for the last 3 years, you have had good moral character. For this, we run a background check and we submit that to immigration. It's also important to note that if you ever committed any crimes, those are especially relevant if they occurred in the last 3 years. A lot of times we could still file if we're able to prove to USCIS that the crime occurred as a result of the abuse. So we're able to tie it. Finally, I'm going to talk about the main element, which is proving that there was abuse or extreme cruelty to the spouse of the US citizen or lawful permanent resident. What does this abuse or extreme cruelty encompass? It could be physical. Obviously, physical abuse qualifies. So if there's a police report detailing physical abuse, perhaps there's pictures or witnesses of the abuse who could provide written testimony. Those are examples of types of evidence that you could provide of the abuse. But in a lot of situations, the abuse doesn't come in a physical way. Many times the abuse or extreme cruelty can be psychological, emotional, could be financial, could be sexual. And that's where a lot of people don't know they qualify. If you're in a situation where you are dominated or controlled, perhaps you're forced to work and turn in your check to your spouse, or perhaps your spouse is someone who's extremely jealous and has to check in on you, or perhaps track where you are. These are situations that could qualify you for, these are situations that could definitely qualify you for VAWA. Now, every case is very different, but I'm just here to tell you today that just because your abuse does not come in the form of physical abuse does not mean that you do not qualify for VAWA. I hope that you take that away from this video, and I also hope that you take away from this video that you could be a man and also qualify. Let's talk about some of the benefits of VAWA. So if you qualify for VAWA and you don't have any inadmissibilities, so obviously please consult with an immigration attorney to help determine your inadmissibilities. I have inadmissibility issues and other video topics, and I will be uploading more. But if you have a VAWA case and no inadmissibilities, perhaps maybe you just have unlawful presence, then you will likely qualify to apply for adjustment of status, even if you never entered with a visa, even if otherwise you would not qualify to immigrate in the US. If you qualify for VAWA and you don't have any other inadmissibilities other than unlawful presence, you can qualify to immigrate in the United States. In other words, known as adjustment of status. It would take approximately 2.5 years to obtain your green card. And again, you do not have to leave the US to, you do not have to leave the United States to obtain your green card. And the best part of it, that while your case is pending, you will qualify for a work permit and travel permit. This past Christmas, I had the privilege to see many clients leave and come back safely with their advanced parole. But obviously, always consult with your immigration attorney prior to leaving the country with advanced parole, because it can be riskier for some more than others. And another benefit is that even if you have an admissibility, it can often be waived in VAWA cases. And there are more waivers available for people applying for VAWA than for people applying through a regular family-based I-130 case. So for example, if you have a permanent bar because you left the United States after more than 1 year of unlawful presence and you re-enter the United States without permission, you have a 10-year permanent bar, which means that you have to spend 10 years outside before you qualify for a waiver. In some cases with VAWA, we're able to seek a waiver where we can tie that to the abuse. And in many cases, even if worst case scenario, you don't qualify for a waiver, what that means is that we may not be able to apply for a green card for you, but we can get you protection against deportation and a work permit that you could renew every 2 years. So this is really life-changing information. Every day I have the privilege to talk to new clients who tell me that they would not have known this but for my videos. So I know how important it is to share this information. It's really important for me to get the word out there because so many people are deserving of this benefit and they do not know it. So if you or someone you know may think that you may be eligible for this benefit, please do not hesitate. I would love to talk to you. You can call me at 310-803-3040 or visit my website. Otherwise, please share this video because someone in your circle may need to hear this and you do not even know that. You know, there's a lot of people who are in these horrible situations and obviously they're not sharing it. So I promise that there's a very good chance that someone in your circle needs to hear this. Thank you so much for watching this video with me today. It's always a privilege and an honor. Please like this video and go ahead and subscribe to my channel and click that notification bell to receive notification every time I'm here with you live. Also when I upload new videos. And please remember that all the information I provided with you today is general information. I am not providing specific advice in regards to your case because I'm not speaking to you personally about your case, but please always consult with an immigration attorney before making any big move. And thank you so much for your time today. See you next time.